For our viewers across Africa and the rest of the world, this is NC Continental Prime. My name is Felicity Ezewike. Thank you for giving us your time. We begin in South Africa, where a court in Pietermaritzburg has ordered a 4-month postponement in the much-delayed trial of the former president Jacob Zuma, who faces charges of corruption in an arms scandal dating back to the late 1990s. The High Court postponed the case to August 15 after Zuma's attorneys submitted a fresh bid for prosecutor Billy Downer to be recused. Zuma's legal team argues that Downer is at the center of a private prosecution by Zuma and is therefore unfit to be part of the case. Judge Nkosinathi Chili presided over proceedings following the recusal of the previous judge in the case, Piet Koen. Zuma and the French arms company Thales are facing more than 700 of charges, including fraud, corruption and money laundering in relation to the multi-billion-dollar arms deal procurement, which took place in 1999.
Yes, by agreement, this matter is adjourned to 15 August 2023 for the hearing of Mr. Zuma's second application for the removal of Mr. Downer, State Counsel, as prosecutor in the criminal trial. That application is set to run for 2 days, that is 15 and 16 August 2023. Paragraph 1, the state is to file answering papers by no later than 26 May 2023. Paragraph 2, Mr. Zuma is to file his reply by no later than 19 June 2023. Paragraph 3, Mr. Zuma's heads of argument are to be filed by no later than 17 July 2023. Paragraph 4, the state's heads of argument are to be filed by no later than 31 July 2023.
Joining us now to discuss this appearance further is legal analyst Mpumelelo Zikalala. Thank you for giving us your time. The developments in court today is that there is a new bid by Jacob Zuma's legal team to remove the state prosecutor. What can we make from this new development?
Good evening to you and also to your listeners. The former president is basically saying, you know, under Section 35, we have a right to a fair trial, and I firmly believe that my fair trial is that I cannot be tried by someone who's attending a case himself, not only a case in which they are the accused, but a case which involves me, or I'm the prosecutor in this case, so they're intricately involved in what is taking place there. Now, it's going to be prudent, or it would be prudent if the court will issue an order that says, Mr. Billy Downer, you cannot prosecute in this matter. We are not saying that don't prosecute me at all. I just don't want you to be the lead prosecutor. Taking into account the fact that you have the National Prosecuting Authority Code of Conduct that says how should a prosecutor conduct themselves when it comes to instituting and defending legal proceedings. And part of it is then to say you must always remain independent, in which the former president believes that when Advocate Billy Downer leaked that information to a journalist, he was not acting in the best interest of his own job, and he was acting in contrary or in contravention of the code of conduct which is applicable to him.
How is this new application likely to unfold, looking at the basis of it and how this case has been unfolding?
That basically needs to convince the court that your rights are going to be infringed if Advocate Billy Downer continues, and that there are no other alternatives other than the order that has to be issued by the court, which then would state or would warrant that Advocate Billy Downer be released or from his position of being the lead prosecutor. But I don't think that the odds are in favor of the former president in this case, because the court has decided previously, when there was a notice to prosecute application that was done in terms of the Criminal Procedure Act, and the court was very clear that the prosecutor is not going to be in your favor all the time. Inherently, they are going to be biased towards the NPA. They are going to want to present their case. The only instances in which you should worry if there are underhand tactics which are now being used by the prosecutor. However, you still have the protection of highlighting those things which are not in line with the law, which are in contrary with the implementation of fairness and justice, by highlighting them as the trial continues. And when you go in an appeal, it's only then in which you are going to highlight those instances and say, you know, I wasn't given a fair trial in this matter. There are many instances in which I was given a raw deal, and these are the instances that I want the appeal court to be able to look at. So the court was clear that if there are alternative remedies which are available, there's no need to bring such an application. And the same could be said here. If you can highlight those instances in which Advocate Piet Koen has acted in a manner in which is unbecoming of a prosecutor, and it is influencing those proceedings which are going to take place now, then highlight those processes as we move along this trial, and do not bring a fresh application, because as it stands now, there's no provision which allows for that, unless if the court then says we are developing a new way of doing things and we want to take into account the conduct of the prosecutor before a matter actually proceeds.
The postponement of this case has been set down for hearing over 2 days, on August 12 and August 16. What is expected to happen on that day?
Between then and now, there are a number of documents which are going to flow from one party to another. They're answering affidavits, they're ahead of arguments, which are basically just a brief synopsis of what you're going to argue on. And on that day, it's basically a presentation of those papers which are being currently, which will be exchanged from now up until August, in which we then have to convince the court in short formats, in a crisp manner, and then say, this is what I'm relying on. This is the source of law that I'm relying on, either through common law or through legislation that has been passed. These are the past cases that have been dealt with by either courts within South Africa or Africa or even internationally. And this is how they've dealt with the conduct of the prosecutor and its impact on one's prosecution. So it's your opportunity to then persuade the presiding officer, in this case, Judge Chili, and then say to him, these are the arguments that I'm presenting to you, and you must find in my favor, because I've been able to put out a cases to say that Advocate Piet Koen must not continue. On the other side, Advocate Piet Koen legal team will then be saying, we do not hear what you are saying. We're still of the view that he is innocent until proven guilty, and there's nothing that has taken any powers away from him from being a prosecutor.
All right, thank you very much, Mr. Zikalala, for speaking with us and sharing your views.
Thank you very much for hosting me.